Welcome, everyone. My name is Corinne Snow. I'm the president of the Harvard Federalist Society. We're a group of moderate, conservative, and libertarian law students. We're not associated with any political parties. We don't support any individual candidates. The society stands for only three principles: that the state exists to preserve freedom, that the separation of powers is central to our Constitution, and that it is emphatically the province and duty of the judicial department to say what the law is and not what it should be. If you agree with any or all of those principles, or if you're just interested in finding out more about our upcoming events and the academic and career resources that we have available, please sign up in the back and please come talk to me afterwards. Now our Vice President of Speakers, Joelle Alisay, is going to introduce today's speaker. Thank you.
Thank you all for coming. Just a quick preliminary note, the Secretary will speak for about 35 to 40 minutes, and then we'll have questions from the audience after that. There's a microphone right here in the center aisle, and you can just line up behind the microphone to ask questions. We will end promptly at 1 o'clock, however, so I might have to cut off questions at some point. Obviously, feel free to leave the room if you have a class that you have to attend. So Secretary Chertoff graduated magna cum laude from Harvard College and received his JD, also magna cum laude, from Harvard Law School. He clerked for Justice William Brennan and went on to a highly successful career as a prosecutor, including serving as Assistant Attorney General for the Criminal Division. From 2003 until 2005, he served as a judge in the U.S. Court of Appeals for the Third Circuit. He was then asked by President George W. Bush to serve as the nation's second Secretary of Homeland Security, a position he held through the end of the Bush administration. The Harvard Federalist Society has asked the Secretary to come here on this week commemorating the 10th anniversary of the attacks of 9/11 to give his reflections on the changes that have occurred in the law since that tragic day, and we are honored to have him. Please join me in welcoming Secretary Chertoff.
Thanks for having me. Thanks for arranging a beautiful day and maybe a little bit warm here in the Boston area, which is why I've taken my jacket off. Also, if you go to the back, you'll see that the society has given the lie to the old adage, there's no such thing as a free lunch. In fact, I wonder how many of you are here for lunch and how many are here for me. But you can keep eating. We are obviously 2 days over the 10th anniversary of September 11th. And if I reflect back 10 years ago to where I was and what I was doing, I was at that point, as was mentioned, the Assistant Attorney General in charge of the Criminal Division of the Department of Justice. I had been in the job for about 3 months. And when I took the job, as all my predecessors had, my assumption is I was going to be spending most of my time doing what prosecutors traditionally do: big white-collar cases, big organized crime cases, perhaps some terrorist prosecutions like what they had arising out of the 1993 World Trade Center bombing or the East Africa bombings. What I did not imagine is that the entire nature of my job would be transformed by the events of September 11th and the radical change it made in the way we operate our security architecture, and also in many ways in the way that we live. Maybe less of a change than people thought it would be, but more of a change than perhaps we envisioned on September 10th. I know that many of you here were probably in junior high school or even younger than that during September 11th. It may be a memory that's a little bit receded in time. What I'd like to do for the first couple minutes is try to give you a sense of what it was like, because I don't think you can understand the legal changes that I think have occurred since September 11th without understanding the very radical change in the nature of the security problems faced by the United States. Prior to September 11th, and certainly after, in that period after the Second World War, really America's involvement in war and in serious threats was an optional issue. Americans chose to get involved in the Korean War, the Vietnam War, the first Gulf War. I mean, I think those are good choices or bad choices depending on the particular war, but there's no question there were choices. In none of these cases was there a direct attack on the United States in its own territory. Likewise, we lived for many years until 1990 with the Cold War, which of course did present an existential threat to the United States, but it was a very stable threat. It was one in which we had a theory of mutually assured destruction or deterrence that worked very well to prevent the Soviets from attacking us or us from attacking the Soviets. And while there was conflict through surrogates in various peripheral parts of the world, again, it didn't really touch Americans in a day-to-day sense, except perhaps for a little bit of a brooding cloud over in a distant horizon. September 11th changed all that. And I was arriving at the Department of Justice when I heard from somebody who I was talking to on the telephone that a plane had hit the World Trade Center. Like many people at the time, I thought it was a pilot error. And then about 15 minutes or so later, I heard that a second plane had hit the World Trade Center. And then I, like most people, understood that we were in fact under attack. I spent the next 24 hours or 23 hours and then the next days and weeks at the FBI Operations Center, which at the time was the location in which we typically managed any kind of a domestic emergency. It was a collection of FBI folks and Justice Department folks, but then they were linked by video conferencing capability to the State Department, to the White House, to the Department of Defense, to the intelligence agencies. And the idea was you could coordinate an event out of any of these locations. What struck me, and I think struck everybody at the time, was the absolute suddenness of this event. The catastrophic nature, and then the fact that we had not had any warning. Remember, in the Cold War, the received understanding was there would be some warning if there was an attack. We had radar, and the radar would tell us that there were missiles that had launched and they were on a course to hit the United States. Our other conflicts developed very slowly over time. At each point, we knew we were getting into a conflict and we were making conscious decisions. This was an occasion when we had a cataclysmic strike at the United States, probably, I think the worst strike inside the United States on any single day in our history, and it came utterly without any discernible warning. Now that presented a couple of problems. One was this the first strike, or were there going to be a second, third, fourth, or fifth strikes? Was this as bad a strike as it was going to be, or were there going to be worse strikes? And as we were at the Operations Center, we learned about the plane that had gone to the Pentagon. So at this point, we're saying to ourselves, wow, we've had two planes in the World Trade Center, a plane in the Pentagon. We then heard about another plane that had been hijacked. And actually, on that day, there were a number of other jets which had hijacking transponders that were turned on as they came in from overseas. So there were points that morning where we seriously contemplated the possibility of perhaps 8, 9, 10, a dozen jets crashing into American buildings, killing not only the passengers on the planes, but people in the buildings themselves. It was during that period of time that the order was given to shoot down planes if we were not able to resolve whether they were hijacked or not. And you may have seen things like this in movies, but let me tell you, it's a lot different when you sit in a video conference and hear people talk about the fact that American pilots are going to be ordered to shoot down American passenger planes on American territory if we cannot ascertain that those planes have not been hijacked. So much of what we did during that day and then the weeks afterwards was first to try to understand who the hijackers were and who they were affiliated with, and more important, who else was out there. Because as we put together a picture of the hijackers, which we did, frankly, partly because people on the airplanes called up their loved ones at home and would say things like people got up in the front of the plane, or they would give us a location for where the hijackers had been sitting, and we were able to cross-reference that with the flight manifests. And so through that process, we were able to actually get a sense of the identity of the hijackers. And then as we went further and looked at how they had bought their tickets, where they had used credit cards to pay for car rentals. We were able to kind of track back over the next day or so where they had been and who they might have been affiliated with. And again, remember, always with the most important paramount requirement to make sure that there weren't other people out there who were going to carry out follow-on attacks. During the course of the first day, there was a fire alarm that went off in the State Department while we were on a video conference, and the people in the State Department said, I think we've been bombed. There were rumors going around that taxi drivers had explosives in the trunks of their taxis and were driving up to public buildings and going to detonate in front of public buildings. So that while with the benefit of hindsight, we know we have a 9/11 Commission report, we know what the original plot was. At the time, of course, we had no idea. And the thoughts that go through your mind are, there could be far worse. There could be a biological attack coming, and of course, as you know, sometime later that fall, there actually was an anthrax attack in Washington and in other places. There could be maybe even a radiological bomb or something of that sort. And so there was a real urgency in terms of proceeding forward. Now, this is a very different role for the Department of Justice than the traditional role. What prosecutors usually do is after a crime is committed or while one is being planned, they go about the process of assembling evidence, the idea being eventually you're going to arrest and convict the people who have either committed the crime or are going to commit the crime. Quite obviously, that is not a model that works with suicide bombers because they're not going to be around to face justice. Moreover, the concepts of law enforcement like deterrence, general deterrence and specific deterrence don't really mean very much when you're dealing with people who have an ideological vision in which their deaths are actually going to reward them for the acts that they've taken an oath to carry out. So the whole notion of the paradigm of how we deal with this really shifted in these days. And something I remember hearing from the then Attorney General, John Ashcroft, is he'd come back a couple of days after 9/11 from the White House, and the president had pulled him aside and said, don't let this happen again. And of course, for those of us who not only witnessed what happened, but also knew people who perished on that day, as I did, that was a very, very powerful injunction. So that is really sets the table for what I'm going to talk about, which is how has 9/11 changed our security paradigm and the laws that go along with it. And what I'm going to say to you is not that 9/11 changed it, but that 9/11 revealed something that had changed in the security paradigm, which we hadn't recognized and which the law had not adequately accounted for. And in fact, one of the lessons I learned over the last 10 years, having been a practicing trial lawyer and a judge, but also having run a large department as a non-lawyer, or not acting as a lawyer, is that often the law becomes kind of a prison of perspective in terms of how you look at solving problems. People begin looking at a problem, particularly in government, as if the law is preordained and you have to fit the facts into the legal boxes. But in fact, other than the Constitution, which is kind of the outer boundary, which I regard as kind of inviolate, all the other laws are subject to change. Congress can change them. If you're in a state, a legislature can change them. Frankly, even the courts change them to some degree or another. So sometimes there's value in stepping back and not saying what is the law, but rather what could the law be and what should the law be. And it is that issue of legal imagination which I think is perhaps to me the most profound element for lawyers to come out of 9/11. Now, back in the days prior to 9/11, my experience was, and I think if you go back and study it, I think you'll find it confirmed, we had a very binary view of what security was about. On the one hand, we had the issue of war. We faced nation states that we were concerned perhaps were going to attack us. We fought 2 world wars involving nation states. Our vision of how to deal with war involved the Department of Defense and the intelligence agencies. There was a body of doctrine and a body of law that governs how you fight a war. And when we dealt with a nation-state threat, that fell neatly in the category of war fighting. There was a fundamentally different kind of security threat we faced prior to 9/11, which of course is something that's been faced over the generations, and that had to do with groups or individuals who simply want to commit violence or mayhem. They want to commit acts of fraud, they want to commit acts of violence, they may be involved in trafficking in illegal substances. And that kind of threat was viewed as completely different from the kind of threat posed in a war. That was viewed as a law enforcement problem. And there we had a separate body of agencies that dealt with the issue. We had a separate body of doctrine about how we contend with criminality. And we had a whole set of laws and processes that we used to resolve whether someone is a criminal and how we deal with them. Many of those laws, of course, arise out of the concern we had in our own country not to allow the government to get to the point where it might actually seriously impair the civil liberties of ordinary citizens. And so you've all heard the motto, it's better that 1,000 guilty people go free than an innocent man should be imprisoned. I might say that paradigm doesn't quite work if you change it to ask this question. Is it better that 1,000 guilty people go free and commit acts of terrorism and kill 1,000 people, or that one person who's innocent be detained? And that changes the calculus, because now you have third-party victims there who might ultimately be paying with their lives if you don't incapacitate someone who's a terrorist. So you'll see that these two kind of well-worn categories don't necessarily fit when you're dealing with mass casualty terrorism. Nevertheless, I will tell you that all during the decades prior to September 11th, all of our government organizations and strategies really organized themselves around this very binary classification of security threats. And there was a very clear, rigid delineation between what the war fighters could do and what you did in a war, and what the law enforcement folks did and what you did in dealing with peacetime criminality. For example, there were geographic limitations, very strong restrictions, basically saying if you're dealing with war fighting, it's likely to be overseas. The military is very restricted in what it can do domestically under a statute called posse comitatus. The intelligence communities are strictly forbidden or very, very carefully curtailed in their ability to collect information about United States persons or about people who are in the United States. It was as if to say when you're dealing with war, that's an away game. That's overseas, it's non-Americans, and all of the institutions that we built to fight wars have to operate outside of our border. Quite the contrary, when you deal with domestic law enforcement, obviously you could operate within the United States and you could operate with US persons, but a very different set of constraints was put upon law enforcement personnel than war fighters. War fighters, for example, are allowed to kill in a war, and you don't have to try somebody before you kill them, and although there are clear rules of engagement and clear constraints, there's much more latitude given to what you can do on the field of battle overseas than what police can do here at home in enforcing domestic law enforcement under this binary paradigm. For example, the police can't just go and find somebody who's a criminal and just shoot them and kill them where they walk around in New York City. You've got to arrest them. There are strict rules about when you present somebody to court. There are Miranda rules about what you can ask them. The need to collect intelligence or information is very much more circumscribed here at home when you're dealing with law enforcement than it is when you're dealing overseas with war fighting and national security. So again, you had a really kind of a neat cleavage between the two functions and the two categories of security. One way to think about it is this way. If prior to 9/11, someone had suggested that the way to deal with organized criminal leadership for drug cartels, let's say in South America, was to attack them with bombs and kill them, nobody would have taken that as a serious suggestion. In fact, what we did was we indicted people, and then we tried to extradite them from places like Colombia or Mexico. Sometimes we were successful in extraditing them, sometimes we weren't, but nobody ever suggested that an alternative to extradition in a criminal case involving the criminal side of the division, nobody ever suggested that using lethal force was an option. But of course, earlier this year, and I think quite rightly, when we were able to finally ascertain that Osama bin Laden was in a compound in Abbottabad, which is a suburb in Pakistan, there was very little hesitation in sending a force in to lethally eliminate bin Laden. And there hasn't been a lot of controversy about that afterwards. I think that was the correct decision, but it is not the decision you would take if you were dealing merely with a criminal defendant. I should point out, by the way, that actually bin Laden has been under indictment for over 10 years for his involvement in the East Africa bombings in 1998. Notwithstanding that fact, I would be very surprised if anybody suggested that instead of sending a SEAL team into Abbottabad, we call up the Pakistanis and say, we've got an arrest warrant for bin Laden, why don't you pick him up and send him back? So you can see the paradigm of these two categories begins to break down. I think 9/11 didn't cause that to happen, but it revealed that it had happened. So let me explain why I think that paradigm has broken down. I think there are three things that have happened since the end of the Cold War that have profoundly changed the world, and therefore the world of security threats. The first is globalization. Globalization has eroded the distinction between the global reach of a nation state and the global reach of a network or even an individual. The ability to travel, the ability to communicate, and the ability to send money around the world has given networks and groups much more global reach than was the case 20, 30, or 40 years ago. In many ways, their global reach is equal to or exceeds that of a nation. And that means that networks can now operate internationally in a way that would not have been true 20 or 30 years ago. Together with that global reach has come a revolution in technology that now allows smaller and smaller numbers of people to cause more havoc and damage than was ever thought possible 30 or 40 years ago. It used to be to cause the kind of damage that we felt on 9/11, you'd have to be attacked by another country. And in fact, you'd have to fly bombers or missiles or have people invade with and be able to use artillery to cause the kind of damage that we saw 10 years ago. That's no longer true. Modern technology allows people to leverage an enormous amount of destructive power. That's true in the physical world. It's true in the world of cyber with computers. It's true if you talk about biological agents, and of course if you talk about the ability to accumulate radioactive material, wrap it around a conventional explosive, and detonate a radiological bomb. So the distinction that perhaps used to exist between the consequences of a nation state going to war and a group committing a criminal act, that distinction and consequence is no longer meaningful. Increasingly, the world we live in will allow small groups of people potentially to cause more damage to the United States or to other countries than was suffered in any of our previous wars. And that again suggests that that line has really disappeared. The third development, which has changed the distinction between the old binary view of war and crime, is that now increasingly within various sovereign nation states, there are what I call ungoverned space, areas where there really is no sovereign authority that enforces the rules or has either the willpower or the ability to impose the rule of law. Whether it's parts of Yemen or parts of Somalia or parts of Pakistan or parts of Afghanistan or maybe even parts of Latin America, there are areas of territory where basically there is no sovereign control. There may be a nominal authority on the part of the central government, but there's no real authority. What happens in those areas of ungoverned space? Well, what the 9/11 Commission report revealed about Afghanistan is that in the areas of ungoverned space there, you had recruiting and training camps, you had laboratories where al-Qaeda experimented to try to come up with chemical and biological weapons. In other words, you had all the infrastructure of a massive level of destruction that was operating in an area where really there wasn't a rule of law. This phenomenon has continued, and as I say, we see in the development of what's gone on in the Horn of Africa and even in some parts of Latin America, increasing no-go zones where either criminal groups or terrorist groups are free to basically train, recruit, and even experiment without much concern that anybody's going to enforce the law against them. So in my view, these developments, globalization, technology, and the rise of ungoverned space, have profoundly altered the landscape against which that old binary war versus crime paradigm operated. And so what I'd like to suggest to you is that 9/11 has revealed that security no longer is binary. It's a spectrum. It basically involves a series of threats, sometimes from nation states, but sometimes from global networks, and maybe going all the way down to lone wolves, that depending on the nature of the technology and the nature of the global reach of the particular threat, the consequences of their acts of violence may be equal to or greater than what we've experienced in conventional wars. And that means trying to figure out what box to put a threat in no longer makes sense in terms of what our capabilities ought to be and what our authorities ought to be. So I'd like to argue that this requires us to have a new paradigm. It doesn't mean that legally anything goes. It does mean that in deciding what the capabilities and authorities ought to be in responding to particular threats, we ought to focus upon a series of policy issues. Policy questions about what we are concerned about from the standpoint of consequence, policy issues about what are the constraints we feel we ought to have in operating in some circumstances, and policies in terms of what we think is the art of the possible. So, let me give you a hypothetical example. Supposing we are looking at an al-Qaeda operative who we know to be a bomb maker. Supposing we locate this person, we identify them, and we see them walking along a mountain ridge somewhere in northeast Afghanistan. What are the tools we ought to be able to use to incapacitate that person? We could arrest them and capture them. That's certainly a tool we might want to use. But in practice, we also might want to eliminate them if capture is not a practical possibility. Now, what happens if that same person were found instead of in Waziristan or in northeast Afghanistan, walking along the streets of Boston? In that case, we could capture them, we could arrest them, no doubt about that. Could we drop a bomb on them or shoot them? I think the answer to that is no. But I think the answer to that is no, not because of the fact that we've put them in a different category, because in Boston, they're no longer someone that is a kind of threat that we can deal with using the tools of war, but only the tools of law enforcement. Rather, because I think there are different policy issues. I think we have policy concerns when it comes to the use of force in the United States or in other areas that are well-controlled and well-governed and well-policed areas, as opposed to when we find somebody in ungoverned space. In ungoverned space, we don't believe that we can necessarily rely upon the ability to capture or enforce the law, and therefore we think it's appropriate to use lethal force in that circumstance if we've identified a threat. Here in the United States or in countries like in Western Europe, we normally are willing to trust the process of governance and the rule of law, and therefore we don't believe it's appropriate to use lethal force in that circumstance, except in a very narrow set of circumstances involving self-defense. So what I'm suggesting is our analysis is not properly based upon trying to figure out what conceptual bucket to put this threat into, but rather a somewhat more finely grained analysis of what ought we be able to do, what ought we be able to do in an ungoverned space, and what we should be restricted in doing in a space that is well governed. So let me lay out a little bit about what I think some of the factors are that we ought to consider as we contemplate the kinds of measures after 9/11 that we might take to deal with threats globally, whether they occur overseas and at home. And I think that you'll see that they don't give you a specific recipe for a rule that always applies in every circumstance. What they do is give you a set of considerations or a set of factors that you have to weigh in determining what ought to be allowed and what courses of action we ought to pursue against certain threats, depending upon what the threat is, what the consequence is, where the threat is, and what our capabilities are. So let me begin by talking a little bit about the nature of the threat. I think few of us would have difficulty in concluding that al-Qaeda and groups that are affiliated with it do constitute a network of threat against which all the tools of national power ought to be deployed. On the other hand, if we look at somebody like the Unabomber, or even Timothy McVeigh, who certainly were very destructive and committed acts of terrorism, I don't think we quite have the same feeling. I don't think we quite believe that all the tools of national power should be deployed against the Unabomber. So my question to you is why? Why do we feel differently? Why is it that a lone wolf operating we ought to perhaps treat a little bit differently than an international global network, even though they're both trying to do the same thing? Well, one difference may be the global nature of the threat. When we're dealing with a global threat that is rooted in ungoverned spaces in other parts of the world, we're facing perhaps a scope of threat that is a quantum level greater than a single individual lone wolf or a couple of individual lone wolves operating in the United States, where we do have a government and a functioning law and order establishment. So I would say to you to consider, at least in the first place, that the international character of a threat raises the level of risk and the level of consequence in a way that makes the use of a broader set of powers appropriate. Second, I think that when we're dealing with overseas or internationally spawned threats, as opposed to purely domestic lone wolves, we do have considerations of our special solicitude for civil liberties here at home that don't apply in ungoverned spaces overseas. The reality is, if you look at the Constitution, much of it is concerned with constraining the ability of the government to turn inward on its own citizens. And our tolerance for the risk of government oppression, perhaps for political reasons, inside our own borders, obviously poses a special set of concerns that doesn't apply if we're engaged in combat operations in a wilderness area somewhere in Somalia. So, now maybe some of you disagree. Maybe some of you believe that our civil liberties concerns in Somalia in a wilderness ought to be the same as here in Boston. I don't think that's probably where the framers of the Constitution would have been. So because of the solicitude that we have to make sure that our government doesn't wind up overstepping in terms of our internal governance, I think we're more cautious and more conservative in terms of the kinds of tools we'll allow the government to use against a purely domestic threat involving a small group or a single lone wolf here at home, as compared to what we might allow in dealing with an international network overseas. A third factor we might want to talk about when we consider the range of tools that we think are appropriate in dealing with a security threat and a terror threat is whether it's motivated, the threat is motivated by ideology or by some other more prosaic motivation like greed or the desire to engage in criminal activity. Now, you might think, obviously we want to treat ideologically motivated terrorism much more seriously and much more vigorously than terrorism which is merely carried out in order to achieve some kind of pecuniary or financial goal. But if you think about it, I'm not really quite sure that that distinction is all that meaningful. If you look at what's going on in Mexico now, the tactics that the drug cartels are using in northern Mexico are pretty much the same as the worst you've seen in Afghanistan or Iraq. You've had beheadings, you had a casino burned down with innocent people inside of it, you've had innocent people rounded up and shot, you've had car bombings. Very difficult from a tactical standpoint to see much difference between what some of the brutal drug organizations in Central America are doing and what the Taliban and Al-Qaeda have done in Afghanistan and Iraq. In fact, we've often seen, or at least occasionally seen, cases where terrorist groups and criminal groups actually wind up making common cause. We saw that in Colombia when the FARC and the drug cartels began actually to work cooperatively together. So it may be that in the end, and I'm not giving you an answer to this, I'm just raising the question, we decide that the factor of whether an ideology motivates a threat should not really be a meaningful factor in the kinds of tools we feel it's appropriate to deploy against that threat. Let me talk about a few other circumstances I'd like you to think about as we consider what kind of tools are appropriate in dealing with very, very serious high-consequence terror threats. Well, one is, again, the question of practicality, geography. When you are dealing with ungoverned space, Somalia, Waziristan, parts of Afghanistan, you don't really have much of an alternative in terms of using non-military types of force. There really isn't anybody who's going to go out and serve the subpoena or arrest the bad actor subject to an indictment. So for obvious practical reasons, that kind of pushes you in the direction of using the pointy end of the spear as opposed to the more conventional law enforcement tools. On the other hand, when we deal here at home, or even in countries where there is a robust legal system and a competent law enforcement authority, it may seem more measured, and it's certainly going to be better in terms of our relations with our allies if instead of going in and using kinetic military force, we use kind of the more conventional and measured legal processes that we often use to extradite criminals. But again, I mean, take the exception of what happened in May with bin Laden. Pakistan is a country which, although some parts of it are ungoverned, the particular location bin Laden was in was Abbottabad. That is about a mile from the equivalent of West Point in Pakistan. There's little doubt that that was very well-governed space. And there's little doubt that there's a functioning court system in Pakistan. So you might have argued in that case that factors should have led you in the direction of calling the Pakistanis up and telling them to arrest bin Laden. But there again, these are considerations, they're not ironclad rules. And the experience with bin Laden, and again I want to reiterate, I think it was exactly correct the way that was handled. The experience of bin Laden indicates that you always have to look at these factors with a very practical approach. Another issue is, what do we want to do with somebody when we capture them? Because that also affects the kinds of tools we use against them. If we bring somebody within the ordinary criminal justice system, and there's a lot of debate about whether we ought to do that with terrorists overseas or even those caught at home, then there's going to be very little information that is likely to be forthcoming from these individuals. Now, that's not 100% true. Sometimes, with some kinds of defendants, getting them into the ordinary civil courts and striking a plea bargain can get them to be forthcoming. But when you're dealing with very hardcore terrorists who are not looking for any kind of plea bargaining and who frankly aren't going to get any kind of plea bargain, it's very unlikely that you'll reach a voluntary agreement to get them to talk. So if they are Mirandized, then they're going to shut down any conversation very quickly, and you're not going to get much intelligence from them except what you can find when you search their premises or when you search their persons. So if getting intelligence is important, that suggests that taking people in a different system, in a military system, where they don't necessarily get Miranda warnings and they don't necessarily get lawyers right away, that may be a more useful tool in cases where somebody might have valuable information to give. So again, that is a factor to be considered in deciding which of the tools in the toolbox we use against terrorists when we capture them. Again, the focus here is practical. So where does that lead me to point in terms of where the legal architecture ought to be? We still have not, 10 years after 9/11, constructed a legal architecture that gives the government the authority to choose in a flexible way among the various tools that I've outlined. Much of the fighting, internal fighting and debate that's occurred in this country about this, the way we prosecute the war on terror or the war against terrorists has been a fight about whether things belong in the traditional bucket of law enforcement or the traditional bucket of war. And because of that fact, in trying to figure out exactly how to use these tools, we've often seen the government try to force a particular fact pattern into a pre-existing category that doesn't really fit. So, we've had the case where we've, on a couple of occasions, detained people in the United States using military authorities, which were upheld by the Supreme Court, but which nevertheless seem a little bit uncomfortable because we don't usually imagine that we need to have military detention inside the United States where we have a pretty well-functioning legal regime. But because we've never had Congress come up with a set of rules to govern how we might do detention in a non-criminal way in the United States when we deal with terrorists, the effort has been to kind of analogize this to a traditional military activity where you capture someone on the battlefield and then use that as the paradigm with a less than 100% satisfactory result. Likewise, when we capture people overseas, there's been a vigorous debate about whether they ought to be brought into federal court in this country. There are obvious problems with collection of evidence when you capture people in a battlefield. And it's also true that when people get Mirandized right away, again, they're not going to be forthcoming in terms of information. But because we haven't come up with a flexible legal architecture for dealing with the various somewhat more subtle considerations about how to deal with people who are caught overseas, we're forced again to get into a sterile debate about whether this is like World War II, where we had POWs sitting in POW camps, or whether this is like the way we dealt with Timothy McVeigh, where he went into the criminal justice system. The opportunity you have 10 years after 9/11 is to look at the nature of the threat, the various factors that we want to consider in terms of where people are apprehended, what are we trying to achieve in apprehending them, what kinds of capabilities do we have in incapacitating people, to look at those factors and come up with a set of legal rules that would give us a legal flexibility that actually fits the facts, one that we make choices about in terms of how far we want to safeguard civil liberties, what the trade-offs ought to be between that and security, but one that is a deliberate choice rather than what I would call an accidental choice in which you try to force a novel state of affairs into a pre-existing set of categories. So that's going to be your challenge in the years to come. We haven't done a very good job in the last 10 years in getting Congress to focus on this. They've done it intermittently. That has thrown a lot of the problem to the courts. I think the courts try to do a good job, but to be honest, it's hard for judges dealing with a problem like this, a case at a time, to fashion an architecture that covers the entire waterfront. So what you wind up seeing is little building blocks put in place, but no real sense of what the total structure is going to look like. You'll have the opportunity maybe in the next years to actually debate and discuss more holistically where the architecture for 21st century security is going to be. Lawyers are going to be a big part of that, and I wish you the best as you go out and you tackle that challenge. So thank you very much, and I'll be happy to take questions.